In today's video, we are going to see probable cause cases where Judge David Fleischer from the Harris County Criminal Court in Houston, Texas, has earned a reputation for challenging weak evidence and holding the state to its constitutional obligations. We've covered probable cause in 2 previous videos, but for those who may not have seen them, probable cause proceedings are judicial hearings that take place shortly after an individual's arrest, especially in situations where no warrant was issued beforehand. Across several hearings, Judge Fleischer examined whether probable cause existed to support criminal charges against the different defendants, with each case presenting a unique question about what the law actually requires before a person can be prosecuted. This video is part of ongoing videos designed to help our viewers better understand how probable cause is applied in the courtroom, especially when assessed by an impartial judge. So let's go with our first probable cause case. On August 23, 2024, defendant Joe Anthony Perez was charged with criminal mischief in violation of Section 28.03 of the Texas Penal Code, based on allegations that he intentionally damaged a gas pump by driving away with the nozzle still attached to his vehicle. A probable cause hearing was held on October 7th in Judge Fleischer's courtroom.
Mr. Perez, you're charged with criminal mischief. You're facing up to 6 months in jail and up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 23rd of 2024, officers were dispatched to a Chevron gas station in Harris County, Texas, in reference to criminal mischief. Officers made contact with the complaining witness, who stated that the defendant was at pump 2 and complained that his card was not working. The complaining witness stated he went outside with the defendant and saw that 25 cents had been pumped, then the transaction was canceled. CW told the defendant that he would have to use the card again to start another transaction. The defendant became irritated and the complaining witness made his way back into the store. The defendant followed him into the store, asked for $30 on pump 2, went out to his motor vehicle and began to pump gas. The defendant entered the motor vehicle with the pump still attached. $30 had been completed on the pump, then the defendant left without attempting to remove the pump, causing the pump and the hose to be separated from the in-ground meter. There were $500 in damages.
Did he mean to do it or was it an accident? Because remember, this is a specific intent crime. You didn't tell me anything that he's like upset to where he intentionally took off with the device.
I understand, Judge.
You know?
I'm just reading based on what the offense report said. It says the complaining witness did not see him even attempt to remove the pump.
I know, but people forget. You know, you're busy. You get this, like, you know, accidents happen, right? But if you're telling me that he's like flipping it off, giving him the bird, yelling at him, and then he just, but I don't see the intent.
Let me see if there's anything more. I pulled up the offense report.
There's no rush. Take your time. Okay, sir, I'm just gonna have you take a seat. I'm gonna do a deeper dive in your case just to see if there is probable cause. If you just don't mind, please take a seat in the jury box and we'll come back.
I say something.
No, don't.
Yes,
You have the right to remain silent. Exercise the right, please. So, as we all know, criminal mischief is a specific intent crime, right?
Judge.
The facts, as we read this criminal mischief, I don't see intent. I may be wrong, but what I see is that I have a gentleman, he gets kind of frustrated that the thing is not working correctly. I guess the pump. So he goes in, pays $30 for prepaid gas, goes out, pumps the gas, and takes off. And I guess in thereby ripping the thing. But is it a mistake? Did he specifically intend to do that? Tell me, what do you?
One moment, Judge.
Take your time.
Judge, I don't see anything per the DIMS nor the offense report that connects specific intent to this defendant.
What was it again? What was your last name again?
Perez. Yeah.
Okay, Mr. Perez, I'm going to find that there's no probable cause to go forward in the case. Understand that this means that I just didn't think that there was intent to rise up for a crime. Whether they come after you still for that, who knows? But
Following dismissal, Judge.
Thanks. If you want to go ahead, well, they're going to dismiss the case now, so you're free to go.
Judge Fleischer finds no probable cause based on the fact that there was no evidence of specific intent to support the charge of criminal mischief. Under the Texas Penal Code, criminal mischief is a specific intent crime, requiring the state to prove that a defendant acted intentionally or knowingly to damage property. While the prosecution pointed to Mr. Perez's earlier frustration at the gas station as a motive, the court determined that a lack of evidence regarding his state of mind at the moment he drove away rendered the incident a civil accident rather than a criminal act. Accordingly, Judge Fleischer found that there were insufficient facts to establish the necessary intent for the crime, and therefore that there was no probable cause to support the charge. The state dismissed the case. While the state's criminal dismissal precludes incarceration or a criminal record, it does not absolve Mr. Perez of civil liability. Under standard tort principles, he remains susceptible to a claim for damages to recover the $500 repair costs. The next probable cause hearing we will review occurred on February 8, 2025. On February 7, 2025, defendant Ramiro Alfonso Jr. Lozano was charged with driving while intoxicated in violation of Section 49.04 of the Texas Penal Code, which makes it an offense for a person to be intoxicated while operating a motor vehicle in a public place.
Gonna take it, man. He doesn't give prior.
Any prior DWIs?
I don't believe he's got any priors of any kind. No.
Good morning, Mr. Lozano. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
Yes, Judge. On February 7th, 2025, at approximately 10:08 p.m., the officer was dispatched to a major crash on the 200 block of South US 50 freeway in Harris County, Texas. The officer met with other officers at the nearby gas station where they had moved the scene. The rear witness stated she was rear-ended by the defendant and was able to put the defendant behind the wheel of the vehicle. The officer observed front-end damage to the defendant's vehicle, and the officer made contact with the defendant, the driver, and occupant of the vehicle. The officer observed slurred speech, staggering, and disorientation and confusion. The standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The defendant stated he did not drink any alcohol that day, and the defendant was read the DIC and refused to provide a breath specimen. A blood search warrant was signed and executed.
Williams?
The judge sounds like there's no probable cause because US 50 is not in Harris County, Texas. That's what the road they said it happened on.
Where is it?
It said US 50, that's not in Harris County.
And the DIMS does say 200 block of South US.
Are you serious?
It says-
Do I need to look it up? I don't know.
Your Honor, the
idea.
DIMS further says during the scene of the accident, which occurred on 200 block of South US 59 freeway, Harris County, Texas. But counsel is correct that before they said he responded to a major crash call for service on the 200 block of South US 50 freeway.
I
So they
just
put,
heard 50.
so they put 50, but then later in the DIMS, they did put 59.
All right.
So they're just two addresses, so I don't know why that's there. But they did say the accident occurred on US 59.
Well, that would be a different story.
Do you have any other evidence that is pointing to that it's at 59 or is it 50?
So, Your Honor, the only thing we have is that statement from the officer, which states that the accident occurred on 200 block of US 59 in Houston, Texas, 77004.
Is that what really happened or was it on 50?
So that's what I can explain is the officer put.
I'm not working on hunches here, man.
And I understand, Your Honor. The officer initially said he responded to a crash call for service, which occurred on US 50, but then later said the accident occurred on 59. So let me see if
It
we,
definitively
I
points.
guess,
There it is.
I'll check the OR and see if they clarify in the complete OR. And in the OR as well, the officer says, which occurred on 200 block of US 50, Houston, Texas, 77004.
So is 50, it's not in Harris
No,
County?
US
He
50,
switches
Highway
between
50.
50 and 59 in the offense report sheet.
I know, probable cause.
Yes, Judge, and we understand.
All right, Joe.
Thank you, Judge.
All right, Mr. Lozano, be careful out there. You know what I mean? Really. Just listen to, he's great. He'll help you out whenever you need, you know?
Judge Fleischer finds no probable cause for the charge because the state failed to provide a factually consistent and legally valid location for the alleged offense to justify the court's jurisdiction. While the state introduced evidence of poor performance on standardized field sobriety testing, the underlying arrest was predicated on a constitutionally deficient report. Under the Fourth Amendment, evidence obtained through illegal or procedurally flawed means must be excluded. As Mr. Lozano attorneys Joseph Francis Vinnis says in the beginning of the hearing, the police report placed the major crash at a location on South US 50, a highway that does not exist within Harris County, Texas. Although the state's DIM's report later mentioned US 59, the presence of conflicting and non-existent addresses meant the state could not definitively prove the offense occurred within the county's jurisdiction. Accordingly, Judge Fleischer determined that there were insufficient credible facts to support the arrest under state and federal law, as well as Article 38.23 of the Texas Code of Criminal Procedure. Evidence that is presented through a constitutionally or procedurally flawed report cannot serve as the basis for a probable cause finding. Following this finding of incongruence, the legal basis for the case was effectively inadmissible. The third probable cause hearing we will review occurred on June 30th, 2024. On June 29th, 2024, defendant Ladarius Devin Ogaro was charged with evading arrest or detention in violation of Section 38.04 of the Texas Penal Code. This statute prohibits a person from intentionally fleeing from a person he knows is a peace officer attempting lawfully to arrest or detain him.
Good morning, Mr. Ogaro. Sir, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On June 29th, 2024, officers were dispatched to an assault in progress in Harris County, Texas. Officers observed a black SUV which had 3 people inside and confirmed it to be the vehicle of interest. The defendant got out of the driver's side of the vehicle and began to walk away from the officers. The officer then told everyone to stop, and the defendant kept walking away, ignoring commands. The officer told the defendant multiple times to stop, but the defendant did not comply and began evading on foot from the officer towards an apartment complex. Foot pursuit began, and another officer then drove towards the defendant and gave verbal commands to stop, announcing Houston police stop. The defendant was eventually caught, and officers were able to place the defendant in handcuffs. The total approximate length was 1/4 mile. Upon return to the original scene, all other parties had left the scene along with a vehicle of interest.
What was the detention for? What was he doing wrong?
Officers were there on an assault call and had a description of the vehicle. And once they saw it, they approached, and that's whenever defendant.
Do you have more than just an assault call? Any kind of identifying factors? I mean, it's really just vague how there's just cars don't assault, you know? Like if there was some kind of description, someone in the car had assaulted someone or something to that nature, you know, but just.
I mean, officers were able to confirm the vehicle by the license plate given from the call.
Okay.
So they confirmed that it was the defendant's vehicle that they approached on.
Do they say that someone assaulted someone, that there were?
Yes, that it was just an assault call, Your Honor.
Yeah, I need more than that. I mean, it's really vague. It's presumptuous. Beetle, do you have anything else?
I'll look at it. Just let me take a look at it.
Okay.
If you just
Just do me a solid, will you? Just take a seat for me. I want to make sure that there's probable cause if there is. If not, I'm going to cut you loose, but I want to make sure that there really is. So just give me a second and then we'll get back with you.
Judge, I see what you're saying. If you want to do whatever you want to do.
That's it?
And then I'll resolve it. I think you were questioning whether it was probable cause.
Right.
Related to the case.
There's nothing new?
I don't really disagree with you.
Okay. Come up, sir. So this was Ogaro. Okay, Mr. Ogaro. I'm going to find that there's no probable cause in your case. Just be careful out there, man. People are always out to hunt you down. You know what I mean? Just be careful. Don't put yourself in the spot. Okay. All right, you're free to go.
Judge Fleischer found no probable cause, ruling that the state failed to prove the detention was lawful at its inception. Under the standards set by Terry versus Ohio, an officer must possess reasonable suspicion based on specific articulable facts before a citizen's freedom of movement can be restricted. Because the officers lacked a constitutional basis to detain Mr. Agaro, his decision to walk away remained a protected consensual encounter rather than criminal evasion. Accordingly, Judge Fleischer found that there was no probable cause, concluding that Mr. Agaro's choice to walk away did not constitute a violation of the law, and the state's case was effectively resolved that same day. The last proceeding we are going to see occurred on July 28, 2024. On July 27, 2024, defendant Catalina Fairman, who was arrested and charged with interference with the duties of a public servant under Section 38.15 of the Texas Penal Code. This statute makes it an offense to interrupt, disrupt, or impede a peace officer while they are performing a duty or exercising authority imposed by law.
Ms. Fairman, you were charged with the offense of interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Officers were dispatched to a family disturbance, and the caller, the defendant's mother, stated that her daughter was walking around with a hammer and identified her daughter by name and as wearing a Barbie sweatshirt. In transit to the scene, the officers observed the defendant's prior mugshot and arrived and observed the defendant recognized by description and that mugshot. The defendant walked towards the officer, and the officers told her to stop, but she ignored them. She had her arms tucked into her sweatshirt, so they were not visible to the officers. The defendant attempted to walk past the officer, and the officer grabbed her arm, and she then laid on the ground and tucked her hands under her abdomen, and the officer struggled to get her arms out from under her. The defendant stated the defendant had a hammer in her left hand and would not let go. The officers then took her into custody.
What's she doing wrong? Was she walking while black? I mean, really, you tell me all she has is a hammer? She's walking around with a hammer. So I hammer stuff all the time.
Your Honor, just what we have is there was a family disturbance. There was a description of her with the hammer, and she walked towards the officer, and the officer just told her to stop.
I mean,
so
there's
they could-
nothing. She's not doing anything. No one says that she's doing anything menacing with the hammer. She's walking with a hammer. I hang stuff on my house all the
Furthermore,
time.
Your Honor, there is more in the DIMS that in the complete DIMS, it says the complainant's defendant's mother identified her and said that the defendant's brother had taken a blue speaker, which upset the defendant. So the defendant went outside and kicked some trash cans over and pacing around a neighbor's vehicle holding a hammer. The complainant advised she was afraid of the defendant. So, yes, Judge.
Ma'am, I'm with you. Don't worry about it. I'm going to find no probable cause. Just hang tight with me for a second, okay?
Good, Judge.
Please.
Judge Fleischer finds no probable cause because there were no specific allegations regarding Ms. Fairman's conduct besides walking down the street with a common tool. As the legal standard for interference with the duties of a public servant requires, the defendant must intentionally disrupt an officer who is performing a lawful duty or exercising lawful authority. Furthermore, the court highlighted the protections of Texas Penal Code 38.15d, which notes that the statute does not apply to instances where the interference is limited to speech or the exercise of one's right to walk away from an unauthorized command. The court held that the mere act of carrying a hammer and subsequently ignoring an officer's command to stop while doing nothing illegal is insufficient to establish a crime. In Ms. Fairman's case, it was only alleged that she was in possession of a household tool and refused to stop for officers, with no evidence supporting any menacing behavior or underlying criminal activity that would have made the officer's initial detention lawful. Consequently, Judge Fleischer found that there was no probable cause, noting that hammering things is a mundane activity rather than a criminal one, and the basis for the arrest was legally fundamentally flawed. These proceedings demonstrate the essential role probable cause plays as a constitutional importance in the criminal justice system. In each hearing, Judge Fleischer closely examined whether the alleged facts truly met the legal requirements of the charged offenses. In all these cases, the evidence failed to satisfy statutory standards, leading to the dismissal of charges before trial. These outcomes highlight the importance of judicial scrutiny at the earliest stages of a criminal case, ensuring that individuals are not subjected to prosecution without sufficient legal or factual support. As these examples show, a probable cause determination is far more than a procedural step. It serves as a crucial check on state power, reminding law enforcement and prosecutors that every charge must be grounded in solid, legally sufficient evidence. If there is a case or courtroom interaction you would like us to examine, let us know in the comments below. Thank you for watching, and don't forget to like and subscribe.